Hey guys, I hope you are doing well, and today I will be discussing with you the classification of property under Hindu law. The concept of property is different under different personal laws. In Hindu law, a lot of importance is given to the joint family structure, which is absent in other personal laws. Under Hindu law, property is classified into two major categories. The first one is the joint family property or co-partnership property, and the next one is self-acquired property or separate property. Now, beginning with joint family property. Joint family property or co-partnership property is the most important aspect of Hindu law. It is like a big reservoir in which property flows from various sources. And in this property, every co-partner has an interest and right over it. And all co-partners enjoy joint possession of such property. Now, the various sources of joint family property are: number one, ancestral property. It is the property inherited directly by a Hindu male from his father, grandfather, or great grandfathers. It is similar to unobstructed heritage. However, property inherited from maternal grandfather and other relatives does not constitute joint family property. Next one is the property acquired at the time of partition. Now, when a co-partner effects partition, then the share of property acquired by such co-partner will constitute joint family property in respect of his defendants. Then comes the property received from father as gift. Now, father has the power to gift all his self-acquisition to anyone, and he can also decide the mode in which the recipient shall enjoy such property. That is, whether he should enjoy it exclusively or whether he shall enjoy it along with his descendant. In the latter case, it will constitute joint family property. Now, next comes the property jointly acquired by co-partners. Now, if a property is jointly acquired by co-partners with their own joint labor and without the aid of joint family funds, then it will constitute joint family property unless the co-partners show an intention to own such property as co-owners among themselves. Next comes the property thrown into the common stock or blended property. Now, if a co-partner deals with his separate property in such a manner that he leaves no doubt that he wants to treat it as a joint family property, then such property becomes joint family property. Similarly, if a co-partner mixes his separate property into a joint family property, then such property converts into joint family property. This is known as blending. Then comes recovered joint family property. Now, if a co-partner recovers an ancestral immovable property which was lost by the joint family, and it does so without any aid from the joint family funds or his fellow co-partners but with their acquiescence, then in such a scenario he shall take 1/4 share of the property recovered as his separate property, and the rest will constitute joint family property. So this was all about joint family property. Next, coming to self-acquired or separate property. Now, the property which is solely owned by a co-partner and has exclusive control over it is termed as separate property. He can dispose of such property in any manner he wants. The various sources of self-acquired property are: number one, gains of learning. It is those gains which are made by a co-partner on account of his training or education. In 1930, Hindu Gains of Learning Act was passed, according to which it does not matter whether the training is specialized or ordinary. Any gains made on account of such training shall constitute the separate property of acquired. Next comes salary and remunerations. Any profit, dividends or salary earned by a co-partner without any detriment to the joint family property, then such profits and salary shall constitute his separate property. Then comes the income of joint family property allotted by the Karta to any co-partner for his or her maintenance. And if after such maintenance any surplus is left, then such surplus shall be treated as a separate property of the person to whom the income of joint family property was given for the maintenance. Then comes government grants. Any property, whether immovable or movable, granted by the government to any co-partner will constitute that co-partner's separate property. Then comes income from separate property. Now, as the phrase suggests, income from separate property or any property purchased from such income shall constitute a separate property of the co-partner. Then comes separate earnings or earnings by self-exertion. Both these types of earnings are made without any detriment to the joint family property and therefore constitute the separate property of the earner. And finally comes the property held by the sole surviving co-partner. Any property held by the sole surviving co-partner shall constitute his separate property and after his death shall devolve upon his heirs by the law of succession, and any custom giving preference to any collateral shall be void. So this was a classification provided by the Hindu law for classifying the property. I hope you like this video. Stay tuned for more such videos. Thank you.